Hi, this is Suzanne Bouchard, instructor with the American Institute for Paralegal Studies. In our Alternative Dispute Resolution class, we've been spending some time discussing the differences between mediation and arbitration. People often confuse those terms, or they mistakenly think that they mean the same thing. But there are some important differences between mediation and arbitration, and I want to discuss those here. First of all, let's look at mediation. What exactly is mediation? In mediation, the parties to a dispute bring in a neutral third party, somebody who's not involved in the dispute, to assist or facilitate in the negotiation process. The mediator's role is to listen to the parties, encourage communication between the parties, help the parties define the problems between them, assist the parties in identifying any common areas of interest, encourage the parties to recognize all of their options, and to facilitate a voluntary resolution of the dispute by the parties. There are several things that the mediator does not do, though. The mediator does not hear and evaluate evidence, determine the merits of either side's case, issue any orders, make decisions with respect to fault, or decide on an award. The ultimate goal of mediation is to achieve a settlement between the parties during the negotiation proceedings. The mediator is an active participant who tries to move the parties forward towards a settlement. But any decisions to reach a settlement and any terms of the settlement, those are all in the hands of the parties. Now let's look at arbitration. What is arbitration? In arbitration, the parties refer their matter to a neutral third party, the arbitrator, who hears each side's evidence and arguments, and who then renders a decision called an award. The arbitrator's decision may be either binding or non-binding, depending on all the circumstances. The arbitrator's role is to act as the focus of the proceedings, the person whom the parties try to persuade of the merits of their case. The arbitrator hears evidence, proof, and arguments presented by both sides, evaluates each side's evidence and arguments, determines the merits of each side's case, and ultimately reaches a decision or an award. Although arbitration seems very similar to a trial, it's much less formal. For example, the rules of evidence may be very relaxed in an arbitration, and the arbitrator may allow a lot more flexibility in the presentation of evidence than what you'd have in a trial. Now, paralegals can be very helpful in both mediation and arbitration proceedings. A paralegal's tasks may include assisting and explaining the process to the client, preparing preliminary documentation, such as the demand for arbitration, gathering and assembling documents, exhibits, and reports, preparing subpoenas or notices, coordinating the scheduling, and even attending the proceedings. As you can see, there's quite a lot for a paralegal to do in support of both mediation and arbitration. Now, if you're not currently a student at AIPS, and if you'd like more information about legal studies leading to careers in the law, please visit our website at aips.com.